guidelines. We get reaction to the decision now from the Assistant U.S. Attorney General speaking to reporters at the Justice Department. This is a little under 15 minutes.
Good afternoon. I'm joined here by Mary Beth Buchanan, who is the director of our Executive Office of U.S. Attorneys. She's also the U.S. Attorney in Pittsburgh. And we have a brief announcement. 20 years ago, Congress enacted the Sentencing Reform Act of 1984, which established a uniform system of fair, tough, consistent, and effective sentencing guidelines. The purpose of that law was to eliminate widespread and unconscionable disparities in sentencing in all federal courts. The system that Congress put in place in 1984 is based on such sound principles as truth in sentencing, limited judicial discretion, the elimination of parole in the federal system, and the similar treatment of similar defendants with similar criminal records who committed similar criminal conduct. In addition, the guidelines allow judges to target longer sentences to especially dangerous or recidivist criminals. In 2002, more than 63,000 convicted defendants were sentenced in federal court under the sentencing guidelines. That's in 2002 alone. Today, Supreme Court ruled that federal judges are not bound to impose on convicted felons sentences that are within the range otherwise required under the federal sentencing guidelines. Although we are pleased that the Supreme Court did not find the federal sentencing guidelines to be unconstitutional, we're disappointed that the decision made the guidelines advisory in nature. Having said that, it is important to note that in spite of this ruling, federal sentencing guidelines remain a critical part of the process to achieve justice. District courts are still required to consult the federal sentencing guidelines, and any sentence may be appealed by either defense counsel or prosecutors on the grounds that it is unreasonable. To the extent that guidelines are now advisory, however, the risk increases that sentences across the country will become wildly inconsistent. The federal sentencing guidelines have put the public's safety first, and the results are clear and undeniable. Tough sentencing means less crime. The rate of violent crime in our nation has dropped to a 30-year low. Between 2000 and 2003 alone, violent crime in the United States decreased by 3%, contributing to the overall drop in the United States of violent crime of 26% in the past 10 years. In the past decade, that has meant 35 million fewer violent crimes. The sentencing guidelines have helped reduce crime by ensuring that criminal sentences take violent offenders off the streets, impose just punishment, and deter others from committing crimes. The Department of Justice remains committed to the core principles and the just foundation created in the Federal Sentencing Reform Act and the guidelines that resulted from that act: fair, tough, uniform, predictable, and proportionate sentences. The Department will continue to urge courts to apply the guidelines and to sentence offenders under the guidelines in order to vindicate those core purposes of sentencing, that similar defendants who commit similar crimes receive similar sentences. The Department looks forward to working on this critical issue with the Congress, the United States Sentencing Commission, the Judicial Conference, victims of crime, and all other Americans who have a stake in seeing justice done. Thank you. We'll take a couple questions.
Do you think after this ruling that judges are going to have too much discretion? Is that a concern for you?
Well, I do think that in the wake of this ruling, judges have more discretion than they did before it. And one thing we do know is that greater discretion tends to mean greater disparity. Having said that, I'm optimistic that courts will, seeing that the way the Supreme Court has approached the guidelines in this case, will view the accumulated wisdom that's reflected in the guidelines as a critical barometer in imposing sentences. In other words, I hope that courts, having been told by the Supreme Court that they should still look at the guidelines, will continue to impose sentences within that range, and that's what we're going to be asking them to do.
What are you going to ask Congress to do?
We look forward to working with Congress on this.
Would your proposal be to amend certain statutes, or would you look to set a new floor for criminal sentences?
I'm not going to be talking about any particular legislative proposals at this time. I will say that, like Congress, we're committed to the principles of determinate sentencing. We know that Congress intended determinate sentencing, predictable, consistent sentencing, and we look forward to working with them in a way that makes sure that that stays the case in this country.
Can I just clarify?
Yeah, Chris, what will federal prosecutors be doing different because of today's ruling?
Well, I think federal prosecutors have been working hard and preparing for this type of eventuality for some time, ever since the Blakely decision came out. Having said that, one thing the Supreme Court's decision says is that we don't have to have a jury trial for sentencing factors. So I don't think you will be seeing prosecutors Blakelyizing, as we've called it in the past, their indictments quite the same way that they have over the last several months.
Can I just clarify?
Some legal experts talking about the decision today see the largest impact in the white-collar and fraud cases, that the leverage you have in getting deals by lording over tough sentences, that will be, that you will have less leverage. Could you comment on that?
Well, I think it's relative. I will say that in white-collar cases, one of the things you tend to see are multiple victims, multiple dollars. There are a lot of sentencing factors that, if you had to try all those issues to a jury, would have made it much more difficult to have the kind of leverage that you're talking about. However, the second part of the court's decision, in other words, the opinion written by Justice Breyer, provides that we can still put all that evidence in front of a judge and argue to a judge that under the guidelines the same sentence should be imposed for a big fraud defendant like the one you're describing. So it remains to be seen, I think, how judges around the country will apply the guidelines when they're advisory as opposed to mandatory.
Chris, because of a sense of urgency about the Blakely decision and these cases, the Supreme Court took these up early. There was this considerable sense of urgency to get the matter resolved. I noted that in the responses to the decisions today that Senator Specter said, okay, we're going to get right on this, and Senator Leahy said, there's no reason that we have to be rushing around now to solve this matter. And I'm wondering what your sense is of a time frame or a degree of urgency in clarifying or dealing with what the court's done today.
Well, I certainly would agree that the federal sentencing guidelines and any decision like this related to federal sentencing guidelines is about as important as anything we do. The federal sentencing guidelines apply to every case we have, whether it's plea, a trial conviction, whether it's a fraud case, a drug case, a violent crime case, it applies to all of them. So in that sense, there's almost nothing more important than our sentencing regime. Having said that, we look forward to working with Congress, I would just say in the near term, to ensure that the principles that they put in place in the Sentencing Reform Act, that is proportionate, fair, consistent sentencing, remain in effect. Yes.
In November, at the Sentencing Commission hearing, you were indicating that there had been a review and some interest in the Justice Department and the Bowman fix, and then in a subsequent meeting with a few of us in your office, you indicated the same. Is that now not true, that we're still interested in looking at a review in the Bowman fix as a potential for statutory relief?
No, I think what I said in my testimony remains true. That particular proposal is one of many that we look forward to talking with Congress about, and there are many advantages to that particular proposal that I mentioned in my testimony. But I said I'm not here to announce a particular legislative proposal. We're going to be looking to ensure that the system that is in place after this decision has those same qualities that we think are absolutely essential and that have contributed so significantly to the major reduction in violent crime around this country that has taken place over the time since sentencing reform has been in place.
Is there some new guidance that needs to go out to the U.S. attorneys now based as a result of this? What kind of communications are you having with your prosecutors in the field?
Well, we're still putting together stuff, but I expect that we'll be communicating with the field in the very near future. We tend to do that anytime there's a major Supreme Court decision, and I don't expect this to be any exception.
Do you think that today's decision will open the floodgates for defendants to challenge the sentences they've been given?
Well, I think the department anticipates litigation over that issue, that is, over the retroactive application of this decision. I think we have the better arguments. I would point to the Apprendi case, which some of you may be familiar with, Supreme Court case from a few years back. All the circuits held that that was not retroactive. So we're going to be arguing that it's not, but that's something I'm sure we'll be litigating over the coming months. I will say that there is, of this decision, you'll note that there were two issues, there were two opinions. Obviously, on the first issue, we're disappointed. On the second issue, the court's ruling is very close to what we asked for in terms of a remedy if the court were going to say that the Sixth Amendment does, in fact, apply to the sentencing guidelines. So there is some good and some bad. But again, the main thing we're going to be looking for is to ensure that we have a system that stays in place, that's tough, that's fair, that's proportionate, that has all the virtues that Congress sought to have in the Sentencing Reform Act, and that courts and lawyers and prosecutors, probation officers, and the Congress have worked so hard to keep in place over the last 20 years. Thank you.
Thank you.
How you doing? Good.